I got to hammer this home. You must read the whole report. Yes?
And ask for the warrant request paperwork, because a lot of that is detailed in there.
Really? Is it sometimes not being included?
I think probably recently it's always included, but back in the day it certainly wasn't.
And you know, something else I didn't know until real recently was that the copy that goes to parents and guardians can often be different than the copy that goes to the attorney, the petition and detention report paperwork. I never knew that. I have often just used them interchangeably, not really paid that much attention to who I was giving, you know, which copy to, and so I do know that that's one of the things that is often not in the parent's copy, you know, the warrant removal paperwork. But yeah, you really want to be reading that stuff. Of course, the most important thing to look at in the warrant removal paperwork is who it was signed by. There are, you know, the judges have a hierarchy here, and we can't ignore that. And there are some judges, if they signed a warrant removal, that is gonna, you know, that you can take that to the bank. And there are other judges who, if they sign a warrant removal, you can probably convince your judge to take a good hard look at it. Yes, Drew.
By detention, I come across the judge wanting to punish my client, where I think there's a safe situation, but the prior situation, the client had obviously screwed up, a dirty home, domestic violence, drugs. You can say you remove them from that situation, but the prior conduct is still there. And they're saying, oh, we can't trust this person because of the conduct, but I'm saying, no, they can move into grandma's house. But it's just hard to make that argument because, you know, even though they're in a new environment, they're still saying we can't trust this person because they were in this prior bad situation.
And your question is, what do you do when you're in that situation?
Yeah, it's frustrating because the judge wants to punish, but that shouldn't be the purpose of the court.
I will challenge you a little bit on saying the judge wants to punish them. Yes, there are judges who are punitive. I fought very, very hard up in Lancaster to get rid of a judge and was successful in getting her transferred to delinquency court because she absolutely wanted to punish. She did not get the dependency system. But if the worse the facts were that give rise to the detention, the better your safety plan is going to have to be. And I encourage all of my lawyers that I train to really look at what everybody else is seeing in the case. To really, you know, put on a minor's counsel hat, you know, just for a second. It's going to, you know, feel awful. But ask yourself, okay, what is the minor's counsel seeing here? And then your county counsel hat, and, you know, that's going to apparently, based on, you know, attrition rates, going to fit more comfortably. And ask yourself what the county counsel is seeing there. And then always, always, always ask yourself what the judge is seeing there. And then prepare your argument. You know your audience. You are going to go in there and you are going to tell a story. And the worse the situation was, the better that safety plan better be that you're going to put into place. So both of the parents moving into grandma's house or grandma moving into the parents' house, that may not be enough. It may need one of the parents to move out on top of that. Or it may need both the parents to move out, and maybe you can get, you know, unmonitored visits in the home so that the mom can basically be there all day long, you know, helping the kids with their homework, cooking, putting them to bed, and just going back and sleeping with dad. You know, really use your imagination. Really try to figure out every combination that you could use with the relatives and friends that you have available. Don't forget, someone I think the other day raised the idea of coaches. If one of the kids is on a sports team, you'll find that coaches are really dedicated to winning. And if they think that one of their star players might be going somewhere where they can't play on the team, they will open up their home. You know, or they will, you know, say, we will go visit every day. We'll go over there we'll take the kid home from practice every single day. That was one I just had. And on the basis that the judge was in court with the family that day, the coach was in court with the family that day, coach was saying, I will take this child home from practice every single day and check things out at the home. And if there's any problem, if I even have a suspicion of any problem, I will take the child home with me and I will call DCFS. Beautiful, right? So you've got to be creative. You've got to look for these things. Now, one of the attachments that you have that we couldn't get
Can I just
copied.
say something? Is that Drew?
Yeah.
You asked a question? I think your question really is, in particular court, you think that the veg officer has gotten tainted by the original allegations, right?
Yeah.
And it really jays his decision,
Yeah,
notwithstanding the fact that you built a good safety plan, correct?
yeah,
And he's also the judge that gets on you because you set, maybe you no time waivers or whatever. Right? He doesn't like it, right? You got to keep doing that. You can't back off from him. You got to keep going forward, doing what you know is right, okay? And sometimes it may require, you know, a Dennis H. or 321 hearing. You did that a few weeks ago, and you got a release, right? So you can't back off from him. Just keep pushing and pushing what you know, what you think is the right thing to do, okay?
thank you.
Absolutely. I have attached the California, or rather the Juvenile Dependency Initial or Detention Hearing Bench Guide. You're going to be getting this in the email from Daisy today. It's not with you right now. That's my fault, but this is pretty amazing. This is exactly what the judges are looking at. This is, and yes, it's 2006. That is the newest one, as far as I could find. So this is what they're looking at. This is one of their prime resources, and we have it. So it's, you know, it's kind of silly not to take a look at it, not to understand what they're being told, and also it contains the scripts. And so when I am talking to my clients, I kind of have the scripts memorized myself by now. But you know, when they say ultimately parental rights may be terminated and the child may be placed for adoption. Now, I think every judge is saying that. Some of them are saying it so fast and mumbling it, you know, because they're almost embarrassed to be saying it. But others are saying it and really looking for, you know, the client to be nodding and understanding that that's something that they can do. So again, just going back to what I was saying before, make sure that they are not hearing those words for the first time in front of the judge. You also want to make sure that, some of these strange words, put yourself in their position. When a client hears that their child has been ordered to have a MAT and HUB assessment, it almost sounds like they're getting a car wash. I mean, you need to explain to them what that is. And because what do you mean? What's my child being assessed for? What's going on? This is such a shock to our clients when, you know, all of these decisions are being made at this hearing and your client has no idea what any of it means. So just explain to them. It's just real quick. You can just say, you know, the department is going to make sure that your child gets checked up. They're going to be doing a mental evaluation and a physical evaluation. And, you know, they may be Christian Scientists, for example. And, you know, if they are Christian Scientists, I've never come across this in all my years, but, you know, one of you will, I'm sure, at some point. And then you can make that argument, and that will be successful. But listen to what your client has to say. Listen to what their issues are. The next thing I wanted to make sure that you all think about that we don't hear enough about, we don't talk enough about, is discovery. So, you know, you've got your defense, you know what your client wants, you've asked yourself, hopefully, the big question is, what do I need in order to prove this? What evidence do I need to admit? Because you're saying it, you're arguing it, even, you know, with mentioning case law and statutes is not going to be sufficient. That's not evidence. All the words that you amass in the world are not going to be evidence. So evidence is stuff that is either documentary evidence that you get admitted into evidence or witness testimony that you elicit on the stand. So you write down on your activity sheet what you need, and if you needed, say we mentioned earlier that telephone log, your client tells you they're saying we have suspicions that this family, you know, is always having fights and the neighbors are always calling the police. And so you know you need that telephonic call log. Then you're going to need to subpoena that yourself. If there is say you've got an E case and you're going to need to collect a bunch of medical records, then you need to be talking with county council about how all of those medical records are going to be received and going to be obtained. Usually you can make an agreement. Most county council understand that if their social worker has referred to a medical record in their report, in the detention report, then they have the obligation to subpoena and provide us with that medical record in its entirety. They can't just put a little sentence into evidence or a comment by a doctor without providing us with all of his reports. In an E case, however, because the child is so young, it is incumbent upon us to also look at other causes of these injuries. So we have to get the birth records. So that means you've got to inquire from your client, where was the child born, and you don't even ask county council to subpoena those birth records. You subpoena the birth records. So that's something that you are going to do on your own. Yes?
I just had a question about maybe kind of balancing where the department, says, well, we have these concerns, these are some of the issues we identify, and you can certainly argue, there's no evidence to support that, and make those arguments, but it seems like on other times, it's easier and better if you're able to say there is no evidence about that, or to obtain evidence to show the contrary, but it's like that's work we're doing versus the department not doing that. But that's sometimes the situation I'm caught in.
Well, you're making two really good points here. One is there is case law that talks about the parents not having the burden to prove a negative. Nobody can ever shift that burden to have us prove a negative. Another time when they do that is when you're asking for relative placement and there's a hit, a klutz hit, like there was an arrest, and so then they want the parents to prove that it was never filed in criminal court. If it was a DA reject, for example. Well, you can't prove a DA reject. You can't prove the absence of a criminal record. So, that argument will lose, and you just want to get that quickly before the bench to make the argument, because you cannot be asked to prove a negative. Just one issue. And sometimes, the other issue that you raise is, yes, sometimes it is sufficient to simply make an argument. You don't have to subpoena records from a hospital that the department says, the child was taken to prove that the child was never taken there. I mean, they're either going to come up with the records or they're not. And if they don't come up with the records, it's their burden. Nothing I'm telling you to do to prepare your defense is meant to take away from the department's burden to prove their case.
But what I end up in a situation is the court then looks at me and says, okay, but I don't feel confident enough because I don't have any evidence to show X, Y, and Z, so where is that? And so then I'm in a situation where if I can get evidence, then the department may release or the court may order that, but I'm stuck in a position to have to get information the department did not.
Well, and that's what I'm encouraging you to do, because your goal, you remember, the end result here is to get your child their kid back, and to do it as quickly as possible. And just a couple of other things to think about discovery-wise. Police reports. I have my attorneys all the time come and say, they didn't attach the police report. I don't know if I should subpoena the police report myself because I'm not sure if it's going to help or hurt my client. Well, you ask your client. You say, listen, you have this full subpoena power of this court behind you. You tell me to subpoena documents or witnesses here, and I will do that. But I don't want, sometimes it can backfire on us if we're subpoenaing witnesses or persons to testify who are going to testify against us. Because then we're actually getting them here in court, and we're putting everybody on notice that they're here. And even if we don't call them, people might know that they're here and we've got them on a witness list, etc. So you talk to your client about that. This is your client's case after all. This is not a call that really you need to make. You need to say, listen, should I subpoena Aunt Gertie? Is Aunt Gertie going to say good things? Or if I subpoena her and put her on the witness stand, is she going to say, bad things? Also, you call Aunt Gertie yourself. But when it comes to police reports, if my client is for some reason unreliable, or I don't know what they're, or I'm not sure if I believe them, I think more evidence is better than less evidence. If they are telling you what their defense is, your obligation as a lawyer is to prepare that defense and to evaluate the defense that they are telling you you have. So if you do not subpoena a document that they tell you is going to help you, then I think you're opening yourself up to an ineffective assistance of counsel. If you subpoena a document they tell you is going to help them and it ends up not helping them, that's not going to hurt you at all. Ms. Hannigan?
So when it comes to police reports, the problem that I have had, that I have had, is when they come to the court instead of our office. And I don't know why it happens with LAPD, but they come to the court. And then the question that I have is, there are subpoena. They shouldn't be going to everyone. They should have come to our office. However, it gets passed out, and all of a sudden the documents that were supposed to help my client walk them into a no FR rec, as you know.
Yeah.
And what...
You do everything you can to say, this is my subpoena, these are my documents. And if a judge overrules you, that might have been appropriate for a writ. Why didn't we writ that?
Because what happened was the judge didn't overrule me, but gave county council the time to subpoena the...
Oh, that's right, they did. Yeah, they did. They gave us the documents.
Right,
They gave
but-
us the police report. We didn't have to turn it over to anybody. And then what happened was, of course, county council would have been, now they would have been not doing their job if they hadn't gone ahead and subpoenaed the documents, that we were fighting so hard to get. Had we known that, they were harmful, we would have just said, keep them, just throw them away. Hand them out, just throw them away. But we didn't know. So, yeah, these are the times that you want to call your supervisor.
Dennis?
Yes?
Margaret, what you said is really, I want to go back, because it's you're correct, the department has the entire burden, the department needs to give us full discovery. All of that is true. It's not how necessarily it works, and we're constantly juggling at what point. So, as you know, I've been in court, recently, so what I've been doing, and I just did it on your case, Emily, the other day, is I asked the court to set a discovery date. So if you know you have a complex trial, you're asking the court to specifically set a date that the department has to provide you the discovery by. Now, some of the judges will do it, some of the judges will put it on for the receipt of report, and if you're in a court where the judge doesn't call the receipt of report, then county council is going to slide on it. And so it is a problem, and for me, the best solution is to just please explain to the judge that county council has got to give you discovery by this date. And I usually do think about it. If we can have a no-time waiver trial, it's going to be within 2 weeks. So again, if you read in that detention report that a social worker is pulling information from medical records, a police report, or something that they haven't given you, you know the social worker has that information. I would say discovery date within 2 weeks. That gives them more than enough time. The problem we have on our e-cases is we want to get that medical evidence to our experts ASAP. And if we have to screw around, having to keep going back to the judge and filing the discovery motions, all that time is time that our experts don't have the medical record. So those are the cases that we're just going to have to go back and forth on. Yes, we can fight the department on it, but at the same time, we may want to subpoena some of those records to get to our expert ASAP so that we can start creating our defense. And it's a challenging issue. I mean, it is.
And setting the date, I was going to actually mention that on the next one. So for C cases, and for many cases, but definitely in C cases where it's emotional distress because of family law issues, you want to get the family law file. And you want to make sure, and the judge will do that. So the judge is going to call over to the family law court, get the family law file, a copy of the family law file sent over here, and you want to make sure you set a date for receipt of that so that everybody can go through the family law file. That's going to be sometimes really critical. And then we often don't think of subpoenaing medical records in our drug cases, our drug baby cases. but thanks to Emily Berger as well, we've found out that there are a lot of documents that are included when there is a nexus between drug use and harm to the child, or risk of harm to the child. And the absence of those documents is very telling. It's the actual document that I've attached to you'll also be getting it in your email today, is called a neonatal withdrawal score sheet. And if you get the birth records, and remember you have to get them on both the child and the mom in a situation like this. And if you get those records and there is not a neonatal withdrawal score sheet, that has to be filled out. That document has to be filled out if the doctor requests it. And if the doctor sees any signs of any problems, of any either drug use by the mother or drugs withdrawal symptoms on the part of the infant, the doctor will order this score sheet be prepared. And if the doctor does not see those problems, then you can subpoena him, or you could get him to write a letter, and he will explain that he did not request that assessment be performed because he didn't see any nexus. That's a possibility.
Dennis?
Yes.
I think it's probably a good time to mention as well that when you get those newborn babies, positive tox babies, usually the only thing that the department is attaching is a unconfirmed test from the hospital. A lot of them are even stamped with not to be used for legal purposes. And oftentimes, the department forgets to subpoena the confirmatory test, so you get to your jurist, and if all they've got is that original test that they stapled to the back of the detention report, they haven't met their burden. So just keep that in mind.
Right,
I
usually-
don't think it gives you much of an argument at detention, because usually the court
Right.
will look at the totality of the age of the baby and all that, but I can't tell you how often they don't
Yeah.
have it at adjudication, and that leaves the court just scrambling with,
Right.
how to make a record.
Yeah, and county council, is often just out of luck, because it usually even says right on there not to be used for legal purposes. Okay, the last thing I just want to make sure I hit you with is a couple of other objections that you want to make. And this is about timing. Remember, it's not, our job to get our clients back their kids someday. It's our job to get our clients back their kids as quickly as possible. And a well-run detention hearing can cut that time, literally by fraction. I mean, way more than cut it in half. And the weapons that we have at our disposal are primarily adhering to timelines. So some people think I have a heavy hand in setting no time waiver trials, especially when I'm sitting in for my colleagues and they're out sick and they come back and they see that 2 or 3 no time waiver trials have been set in their absence. But to me, there has to be a reason not to set a no time waiver trial. There are plenty of them. We need to get a lot of medical records. In order to make this fit under Destiny S, I really feel like my client needs to have a couple of clean drug tests. I need to get, there's going to be a lot of investigation I need to do here. I can't think of all the reasons, but if you have a great reason, then fine. Go with the waiving of the time. But if you can't articulate the reason why you're waiving time, I don't think it should be waived. Yes?
I just want to chime in because I was going to touch on this in my training that I'm going to have in a few weeks, and I have never regretted setting a no-time waiver, but I've often regretted not setting one. You need to ask yourself, why am I giving the department more time to get more evidence against my client? And in Ray Rebecca C was a no-time waiver trial, in which I did not allow the department to have any more time than possible to get any evidence against my client. So, and also, I think people sometimes don't think about no time waivers when the children are with the client.
Mhm.
But you can still set the no time waiver, it just goes out 30 days. But in many courts, that's still going to be a lot earlier than
Right.
otherwise.
Right.
And so you need to consider that as well.
And the hardship on, a mom with 4 kids of having dad out of the house, that additional week or month is going to matter a lot to her. And the other objection you must waive is, it's come to my attention, oh, Rosetta?
Oh, I was just gonna say, when I set no time waiver trials and then I come to the day of the
It's not the experience of anybody in 404, it's not the experience of anybody in a couple of other courtrooms, but again, you know, don't set it if you don't think you're going to be able to get ready. You know,
Well, I think that though you can make the argument, for instance, Rosetta, because you're getting that report, that JDX report maybe comes in the morning of, there might be information in there that wasn't available to you before, which would give you potentially good cause to request a continuance of that adjudication.
it could, yeah, that could happen.
Or the First Amendment.
Again, I think the best, just for the record, the best thing that I heard all day was, I've never regretted setting a no-time waiver, but I have often regretted not setting one, so that deserves a cup of coffee. Let me just see if anybody can get this one. For the last gift card of the session, how do I phrase this? What other time objection do you want to make sure that you are making if it's important?
Say that again?
Yeah, that's not a good question. Let me see if you can answer it anyway.
Notice?
No. What I'm thinking of
See
is,
the reports?
No FR?
I'll phrase it this way. Okay, so the judge says, you know, you're not setting a no-time waiver, and the judge says, it's today, we're in real time, so today's February 23rd? 24th. Okay.
Dennis is real time.
And March, April. Okay. And so the judge says, I'm setting the adjudication for April 29th.
Objection.
Not you, you're a writ attorney. What's the objection?
60 days.
Ms. Rebecca.
So it's beyond 60 days.
Exactly. And you have to make that objection, and then you can, and if she still does it, then you can file that writ, and we can maybe get the judges who are abusing the dates, you know, correcting their situation. Because that has to be objected to, and what specifically are you objecting to? Because the judge is then going to say what? That there was good cause. There's good cause. Or good cause for a continuance. Say you come back for an adjudication in a month, and then they set it out, you know, past the 60 days. And county council is asking for the continuance because they need to get some document or something. You have to make the objection, and you have to object to the good cause. You have to object to the good cause finding, and you have to object to the continuance. Yeah? Yes.
What if you object to that it's more than 60 days and your judge says something like, which I can just imagine my judge saying, like, oh, okay, you want a no time waiver trial then? We can do that. And
Well, I mean, I would tell the truth. I would say, Your Honor, I don't feel the need to request a no-time waiver trial, but I am asking that the court set the adjudication according to statutory guidelines.
But they can't say, okay, then I'll set it in 10 days from now?
Well, they can't do 10 days. The 10-day trial is only available after as an option to a denied 321 motion, which has been deemed too complicated for me to go into here. I've had so many hours of meetings about the 321. It's just, if you think you see it, call your supervisor, is all I will say. But no, they wouldn't have any grounds to set a 10-day. I've never heard of that. I've never seen a judge punish me by giving me a no-time waiver. Because really, they're not punishing me, they're punishing the department. Oh yeah, that would be why. Because it's not a punishment to me. So they would be punishing the department for my objection. They're not going to do that.
Can I just add one thing? In the courtrooms where they're putting the cases over past that period of time, it's because of court congestion. My suggestion of how we relieve court congestion, just think about this. Your loser cases in which the client has come to you and said, I'm in my drug program, I was doing drugs, or I am trying to get into my domestic, you know you're gonna plead that case up. Set it for a no-time waiver trial. That client should be getting FR within 2 weeks. Move it. And that will clear, no-time waivers can clear the court's calendar for the more serious cases. Because, again, if you don't really, if this is a case that's gonna settle, why not settle in 2 weeks? And what Emily is saying is the department will have less time to find more crap on your client if we settle it within 2 weeks. So no time waivers can be very, very helpful on those certain cases, especially if your client's already in the program, already testing, you know, and sometimes those folks do come to us right at the arraignment. Why not set that for, no